Misrepresentation in English contract law and English tort law refers to a situation where a person is induced to enter into a contract entirely or partly by a false assertion made by the other contracting party. Claims that can be described as sales talk, such as advertising slogans, are not misrepresentations. If a misrepresentation is incorporated as a term of the contract, it may form the basis of an action for breach of contract, and contractual remedies. If not, the misrepresentee may be able to rescind the contract or obtain damages. A misrepresentation may be made fraudulently, negligently, or non-negligently. A related term is misstatement, a false assertion that causes harm other than by inducing a person to enter a contract. Contract law deals with the contractual implications of misrepresentation. In most cases, English law allows escape from a bargain when a contracting party has not given true consent due to misrepresentation. Tort law deals with civil wrongs and remedies. When a misrepresentation has been made and an agreement was concluded, the misrepresentee does not have to bring a halt to the deal. Misrepresentations generally do not render a contract void, as does the contractual doctrine of common mistake or frustration. It makes a contract voidable at the option of the misrepresentee. Not all contracts entered into on the strength of misrepresentations will be bad for the misrepresentee, who may choose not to void the contract. Remedies are partly regulated by the Misrepresentation Act 1967. English law generally allows a contract to be unwound, so that both parties are put back into the position before the agreement was made. It may be that the misrepresentation was incorporated into the contract as a term, so as an alternative one can claim the contract should subsist and claim for a loss in expectations. In this case, the misrepresentee can equally sue for damages as if the misrepresentation had been true. A misrepresentee may also sue for any losses due to relying on the misrepresentation. In some cases, a claim for misrepresentation in contract may also in parallel be grounds for an action for deceit in tort, which has different rules and a different basis for damages. What is misrepresentation? A misrepresentation is a false statement of fact or law that is relied on by the other party in entering a contract. For example, in Curtis v. Chemical Cleaning and Dyeing Co. Ms. Curtis took a wedding dress with beads and sequins to the cleaners. They gave her a contract to sign and she asked the assistant what it was. The assistant said it was to stop risk to the beads. In fact, the contract exempted all liability. The dress was stained. But the exclusion was ineffective because of the assistant's misrepresentation. The law does not consider that mere puff, or sales talk are misrepresentations. For example, a second-hand car dealer claiming this is the fastest car ever, or a washing detergent company advertising that their product will clean your clothes whiter than white are not considered misrepresentations, as a reasonable person would be unlikely to take such claims seriously. There are two essential steps in claiming a remedy for misrepresentation. The first is to show that a misrepresentation took place, and the second is to show that it was relied upon when entering the contract. Misrepresentation equals, not every statement spoken without the utmost truth is a misrepresentation. It is generally said that the statement must be one asserting something as a fact, rather than as an opinion, and that statements of intention are not statements of fact. However, opinions and intentions can overlap with facts. It is not considered misrepresentation when a contracting party does not correct an error in his favor made by the other party. In some cases, a claim for misrepresentation in contract may also in parallel be grounds for an action for deceit in tort, which has different rules and may be advantageous in some circumstances. Statements of opinion. Though a statement of opinion is generally not actionable as a misrepresentation, by giving an opinion the party may be held to have represented that they had better knowledge about certain facts. For instance, in Smith v. Land and House Property Corporation, Boyne L.J. held that Mr. Smith could not enforce a contract against L.H. to buy his property, because he had advertised that the current tenant, Mr. Fleck, was most desirable. In fact, as Mr. Smith knew, Mr. Fleck had been missing his rent payments and was then declared bankrupt. So even though most desirable is an evaluative statement, it is still a misrepresentation because it warrants the statement maker has good knowledge of certain facts. the cases seem to show that the divide between fact and opinion is partly affected by the balance of knowledge and expertise between the parties. In Bissett v. Wilkinson, Mr. Bissett said his land in New Zealand could support 2,000 sheep. Both he and Mr. Wilkinson knew sheep had not been farmed before. Mr. Wilkinson tried to pull out after the contract was signed, but the Privy Council advised that the statement was only one of opinion, not fact, given that there was no dishonesty, and considering the knowledge of the parties respectively, and their relative positions. In the more recent case of Esso Petroleum Company Limited v Marden, Lord Denning Mr. emphasized again that knowledge of facts was crucial in being liable for a misrepresentation. Here Esso told Mr. Marden, a prospective franchisee, that its Southport petrol station would have 200,000 customers a year. In fact, the projections were wrong, and so Mr. Marden was entitled to claim compensation for his losses. The distinction between Esso and Mr. Bissett is that Esso was in a far better position to know what was true. Statements of intention, statements of future intention are not generally actionable representations, so that someone who fails to carry out a stated intention is not making a misrepresentation. However, a misrepresentation of one's present intention is actionable. As Bowen L.J. said in Edgington v Fitzmaurice, the state of a man's mind is just as much a fact as the state of his digestion. So where Mr. Edgington had bought shares after he heard the company was seeking capital to expand, but in reality it was to pay off debts, he was entitled to rescind his purchase. Silence and omission. Only in special categories of contract such as partnership or insurance contracts is there a duty of utmost good faith by which both sides are meant to disclose to each other all material information. For example, in Lambert v Cooperative Insurance Society Limited, the co-op was entitled to rescind their insurance policy with Ms. Lambert and not pay up on stolen jewelry because she had failed to disclose that her husband had been convicted for theft. By contrast, in ordinary contractual situations, there is no such duty. As Chitty J. opined, a mere silence as regards a material fact which the one party is not under an obligation to disclose to the other cannot be a ground for rescission or a defense to specific performance a unregistered trademark. However, several qualifications exist. First, if a representation was made during negotiations, which later transpires to be no longer true, there is a duty to make a correction. So in with the O'Flanagan, where Dr. O'Flanagan told Mr. Wood that his medical practice earned £200, but when the contract was signed the income had dropped to £5, Dr. O'Flanagan was under a duty to correct himself. Representations are continuing. Second, one cannot simply tell half-truths, as for instance in Dimilk v Hallett, where a land vendor said 2 farms were fully let but did not say the tenants had given notice to quit. This was misrepresentation. Third, it can be a misrepresentation when a person says they are unaware of something, but have in fact done no checks. This was the situation in Knott's Patent Brick and Tile Company v Butler, where a land purchaser asked the vendor's solicitors whether there were any restrictive covenants and the solicitor said he was unaware of any. It was true that the solicitor was unaware, but it was also a misrepresentation. Reliance equals. It is essential that there is some connection between a misrepresentation and a claimant's entry into the contract. For instance, in Atwood v Small, Mr. Small made false claims about the capabilities of mines and steelworks, which he was selling to Mr. Atwood. Mr. Atwood said he would verify the claims before he bought. He employed agents to check. The agents say the claims were true. It turned out they were not. But the House of Lords held that Mr. Atwood could not escape the contract, since he did not rely on Mr. Small. He relied on his agents. The requirement for reliance has not been pushed so far as to say that a misrepresenter is never liable when a misrepresentee could have found out the truth. In the leading case, Redgrave v. Hurd, Mr. Hurd was told by the elderly Mr. Redgrave that the solicitor practice earned £300 per. Mr. Redgrave told Mr. Hurd he could check some documents in the office to prove it. Mr. Hurd did not check, and subsequently signed a contract to join Mr. Redgrave as a partner. Then Mr. Hurd found out the practice only generated £200 per, and the documents in the office had never said otherwise. Lord Jesselmister held that the contract could be rescinded for misrepresentation, because Mr. Redgrave had still made a misrepresentation. Furthermore, it would be inferred that Mr. Hurd relied on the statement from the fact that it was untrue. Edgington v. Fitzmaurice confirmed further that a misrepresentation need not be the sole cause of entering a contract, for a remedy to be available, so long as it is an influence. Redgrave v. Hurd raises another question, about contributory negligence under the Law Reform Act 1945. In the case, Mr. Redgrave's mistake was referred to as innocent misrepresentation, though it is very arguable that it was at least negligent. Was it negligent of Mr. Hurd to not check the papers as well? Had Mr. Redgrave been fraudulent, it is clear that any negligence on Mr. Hurd's part could not affect his right to compensation. However, damages for negligent misrepresentation and damages under the Misrepresentation Act 1967 S2, 1, can. Rescission. The first possible remedy for misrepresentation is that the misrepresentee may be entitled to rescind the contract. This means that the contract is taken back, as if it had never come into existence. The misrepresentee would then be entitled to compensation to put him back in the position as if the contract had not taken place. Rescission is distinct from termination of a contract, whereby a breach of a term cancels future performance, and only extinguishes the contract prospectively. For rescission, the claimant may have a restitutionary remedy to recover any enrichment that a defendant has received under the contract. The claimant may also have a tort claim for any losses that had arisen. In principle, a rescission remedy is available for fraud and negligent misrepresentation as of right. For innocent misrepresentation, however, Misrepresentation Act 1967 S2, 2, gives the court discretion to award damages instead of rescission if undue hardship to the defendant would result. Part rescission is not yet available in England. A misrepresentee does not have to exercise the right to rescind a contract, and have it declared void. A contract is always voidable, and it exists until the option to void is exercised. If one's wish to rescind is clear, this will be effective even if not communicated to the misrepresenter, but to some official authority like the police or a motoring mutual society. When a contract is entered into after the misrepresentation of a third party, this area resembles the law on undue influence. In TSB Bank plc v Camfield, a wife guaranteed repayment of her husband's partnership's loan through a mortgage over her house. Her husband innocently misrepresented that the maximum liability was £15,000. Applying Barclays Bank plc v O'Brien, the court held she was allowed to rescind the agreement. She had not given true consent to the charge. Another example beyond the typical husband mortgage scenario is if a consumer buys goods from a retailer on the strength of a manufacturer's advertising. When rescission is claimed, it is not possible to also claim expectation damages as if the contract were to be performed. Either rescission, or damages as if the contract was still in force, can be claimed, but it would be inconsistent to do both. In Whittington v Sealhane, it was held that damages for losses as if the contract was still in force, and to put the claimant in the position as if he had never entered it, could not both be claimed. So where Mr. Whittington's prize poultry died on a polluted farm which Sealhane represented was sanitary, Mr. Whittington got an indemnity for council rates and repair costs, but not for the loss of profits. At the time it was not possible to also recoup costs for the dead poultry, but later Hedley-Byrne Negligence or Misrepresentation Act 1967 S2, 1, provided this remedy. Bars to rescission the right to rescission may in four circumstances expire. Rescission is often a drastic solution, just as the right to terminate for a contractual condition can be an oppressive right when exercised. So as an equitable remedy, the courts developed principles which would take away the right if it seemed unfair on the defendant, some third party, or too rich for the claimant. Counter-restitution impossible, with a somewhat technical-sounding name, this is the most important bar to rescission in practice. Counter-restitution simply means putting the parties back to their positions before the contract was consummated. For example, if our contract was a pen for £1, counter-restitution would mean you giving back the pound and me giving up the pen. The aim is to ensure that a claimant is not unjustly enriched as a result of rescission. It used to be that common law courts insisted on precise restitution. So in Clark v. Dixon it was held that a defrauded investor could not rescind the purchase of his shares because the investment was bound up in the company and the shares were now worth less. Precise counter-restitution was impossible. However, the rule was mitigated, becoming more lenient. Now only substantial restitution is necessary. In Alanger v. New Sombrero Phosphate Company, promoters did not tell investors that a mine on Sombrero Island had been bought by the promoters for half the price that they were now valuing it for in the company. By the time investors realized, however, a substantial amount of phosphate had been mined. It clearly could not be put back in the ground. But Lord Blackburn held that since substantial restitution could be paid, rescission of the share contracts was not barred. Affirmation: if a claimant through conduct has subsequently affirmed a contract despite some prior misrepresentation, she will be stopped from changing her mind. For instance, in the slightly harsh case of Long v. Lloyd, Mr. Long bought from Mr. Lloyd a lorry advertised as being in a Euro exceptional condition, a Euro unregistered trademark said to do 40 miles per hour and 11 miles to the gallon. When it broke down after 2 days and was doing 5 miles to the gallon, Mr. Long complained. Mr. Lloyd said he would repair it for half the price of a reconstructed dynamo. Because Mr. Long accepted this, when it broke down again, PSLJ held the contract had been affirmed. It was too late to escape for misrepresentation. A more lenient approach may now exist. As Slade LJ pointed out in P. Mann v. Lanjani, actual knowledge of the right to choose to affirm a contract or rescind is essential before one can be said to have affirmed a contract. Third-party rights. A clear bar to rescission is where unwinding a contractual exchange may cause injustice to an innocent third party. This will particularly be the case where an item has changed hands and then been sold on to a third person. If the first contract is declared void, then the second contract with the third person would also be void, due to the principle of nemo dat quod non habet. However, the equity courts decided that a contract could not be declared void if a third party's rights had intervened, provided the third party had acted in good faith and given consideration. So in Phillips v. Brooks Limited, it was not possible for a jeweler that had been defrauded by a rogue to claim back a ring from the pawn shop where the ring had been sold on. Phillips v. Brooks Limited, however, stands tensely with another area of the law known as the doctrine of mistake as to identity. The House of Lords by a thin majority recently reaffirmed in Shogun Finance Limited v. Hudson that when a contract is done at a distance, but where the identity of the contracting party is essential to the transaction, the contract will ex ante be void. In these cases, the courts have deviated from a normal misrepresentation and bar to rescission analysis. Lapse of time. The fourth potential bar to rescission is that the right will be lost if a claimant takes too long to bring an action in court. The old term for lapse of time is laches. The amount of time that needs to pass is not specified, and a judge will decide that on a case-by-case basis according to what he thinks is fair. The leading example is Leaf v. International Galleries, where Mr. Leaf was told he had bought the painting Salisbury Cathedral by John Constable. It was in fact a photocopy. Mr. Leaf was told this 5 years later at an auction. However, Denning LJ held that by this time it was far too late to rescind, even though the painter's identity was clearly a condition that went to the root of the contract. By contrast, the Limitation Act 1980 S5 gives a 6-year limit from the date of a breach of contract to claim damages. This was an available remedy for Mr. Leaf, though in pleading the case the lawyer had forgotten to include that point in the statement of claim. Citation missing. Royal prerogative exception. A historical antiquity remains that the reigning monarch can bar you from rescinding if the contract's continuing effect is in the public interest. Queen Elizabeth II has not exercised this power since the Falklands War. It has been noted that laches is a somewhat uncertain unregistered trademark doctrine. There is authority that an innocent party must have known of a right to rescind before time starts to run, which seems to contradict the decision in Leaf. Communication of rescission equals, in order to rescind a contract, it is normal to communicate the intention to rescind to the misrepresenter. However, this is not necessary, so long as a misrepresentee unequivocally communicates their wish to no longer be bound to someone. In Car and Universal Finance Company Limited v. Caldwell, Mr. Caldwell told the AA and the police that he had been given a dud check for his Jaguar by a rogue. It was held that this was an act showing the wish to no longer be bound, so a car dealer that ended up with the vehicle, even though they had paid good money, had to give it back. This decision may be justified on the basis that in such rogue cases, the third party could protect herself by checking with the authorities that the vehicle they were buying is not stolen. Removal of bars to rescission, Misrepresentation Act 1967 S1 older cases had held that if a contract had already been performed, or a misrepresentation had become a term of the contract, this would preclude rescission. This inflexible position was amended by the Misrepresentation Act 1967 S1, which simply says such bars no longer exist. However, it must still be remembered that one cannot ask both for rescission and for recovery of expectation damages for breach of contract. Damages, whether a claimant can seek damages depends on whether the misrepresentation was innocent, negligent or fraudulent. The damages available will reflect losses, not a person's expectations, unless the misrepresentation was a promise incorporated as a term into the contract. Provided no double recovery results, it is entirely possible to rescind and claim damages. There are 4 categories of damages claim, which are a combination of common law and the Misrepresentation Act 1967. Fraud or deceit Deceit, fraud, and fraudulent misrepresentation, are all legal terms related to deliberately making an untruthful statement. In law, the criterion used is that the person did not actually have an honest belief that their statement was true. More exactly, it is an untruthful statement that is made knowingly, and either without belief in its truth or reckless as to whether or not it is true. At times, recklessness, silence, or omission can also be enough to make a misrepresentation fraudulent or deceitful, for example where the person showed either utter indifference or a lack of care whether or not the statement was true, or deliberately stays silent when a previous statement is no longer the case. This can also include not bothering to check whether or not the statement is true. Fraud and deceit differ from negligence, because they are based on dishonesty while negligence means something closer to unreasonable carelessness or lack of expected professional skill. In law, deceit and fraud both fall within tort and are also often crimes, while fraudulent misrepresentation is usually associated with contract law. In a claim for deceit or fraud, damages are intended to put the claimant in the position as if the tort had not been committed. Therefore, a claim for damages from any of these requires that the statement was reasonably relied on, and that this reliance led to loss or harm. The motive for dishonesty is irrelevant, so a good motive does not change the fact of deceit or fraud. Just because a belief is unreasonable does not mean a statement is fraudulent, but it could be evidence of dishonesty. Pleading fraud or fraudulent misrepresentation should be undertaken with care, since it is a more serious claim and therefore will be looked at more stringently. If the case is lost or the claim would make no difference to the outcome, then any award in respect of the defending party's costs may be higher as a result of extra work to defend the claim. On the other hand, to not plead it when applicable may reduce the outcome of the case. The leading case, Derry v. Peake, defines deceit, although it was not actually held in this case that deceit took place. Mr. Derry had bought shares in a tram company which advertised new trams it was building had the right to use steam power. The Board of Trade would only let the company use horse-powered trams and the company was wound up. When Mr. Derry sued the company's directors, Lord Herschel found that this was not deceit since the directors honestly believed in their statements at the time and thought steam power permission was a mere formality. He noted, the ground upon which an alleged belief was founded is a most important test of its reality. If I thought that a person making a false statement had shut his eyes to the facts, or purposely abstained from inquiring into them, I should hold that honest belief was absent. Unregistered trademark. A number of cases illustrate how seriously common law takes deceit. In Doyle v. Olby Ltd, Mr. Olby was fraudulently told that the ironmonger's business he was buying was half brought in through a traveling salesman. Lord Denning Mr. increased the award given at trial to reflect the whole difference between Mr. Doyle's position before the fraud and his position now. Any loss flowing directly from the fraud was compensable, because, he said, it does not lie in the mouth of the fraudulent person to say that they could not reasonably have been foreseen unregistered trademark. Further illustrations are plentiful. In East v. Morrow, where Morrow lied that he would not set up a barber competing with the one he was selling to East, Morrow was liable for East's normal market lost profits, costs of improvements and the price paid minus the business selling price. In Smith New Court Limited v. Scrimgeour Vickers Limited, Smith New Court Limited was deceitfully told there were close rival bids for shares in a company called Forantiers Incorporated. Smith New Court Limited bought, but then it transpired that massive fraud had occurred. The Court of Appeal held that only £1.2 million was recoverable, the difference between the market price at the time of purchase and the real price, but the House of Lords held that the full losses of £11.8 million were recoverable because that loss was one which Smith New Court Limited had due to entering the transaction after being deceived. In practice, because an action for negligent misrepresentation has now been developed through Hedley-Byrne and the Misrepresentation Act 1967 S2, 1, it is often not beneficial to sue for deceit. The only certain difference is that the defense of contributory negligence is unavailable in a deceit action. But deceit is harder to prove, since evidence of a person's state of mind is needed. Because the charge can sink people's reputations, alleging deceit is also contrary to professional conduct rules at the bar, unless a good case exists. A large difference which is subject to debate, is that the causation and remoteness rules are more generous for deceit. Certainly this is true when comparing negligence and deceit. However, the Misrepresentation Act 1967 S2, 1, which was modeled on the law as it stood when the Act was passed, has the same causation rules as for deceit. Negligence equals. Negligent misrepresentation occurs when one party innocently but carelessly makes a false statement and the other party reasonably relies on it, suffering a loss as a result. After Derry v. Peake, it was thought that negligent misrepresentation was not actionable in tort. However, in Nocton v. Lord Ashburton, a claim was allowed where parties were in a fiduciary relationship, and in Candler v. Crane, Christmas and Company, Denning L.J. delivered a blistering dissent against the bar to recovery for negligent words. His dissent was approved in the leading case, Hedley-Byrne and Company Limited v. Heller and Partners Limited, where Heller and Partners Limited warrant to Hedley-Byrne and Company Limited that its prospective client, Easypower Limited, was creditworthy. When Easypower Limited could not in fact pay for the advertising services, Hedley-Byrne sued the bank for misrepresentation. This is a tort action, so the question did not actually involve a claim for misrepresentation inducing a contract. But the principle was the same. Could one sue for losses after being told negligent, rather than fraudulent, statements? The House of Lords answered yes if there was a special relationship between the parties showing that one had assumed responsibility to the other. In the instant case this would have worked, except that Heller and Partners had said in their warrant that they disclaimed any responsibility for their statement's accuracy. They had an exclusion clause. So in absence of the exclusion clause, Heller and Partners would have been liable for negligent misstatement. Even if Hedley-Byrne was not a contract case, Esso Petroleum Company Limited v. Marden confirmed that its principles were applicable to negligent misrepresentation preceding a contract. Since the same principles apply, it has been held that where a representative is also partly at fault for his loss, her damages can be reduced under the Law Reform Act 1945 S1. However, it will almost always be more advantageous to sue under the Misrepresentation Act 1967 S2, 1. Misrepresentation Act 1967 S2, 1, equals. The Misrepresentation Act 1967 followed on from the Law Reform Committee report of 1962, produced a year before the decision in Hedley-Byrne was concluded in the House of Lords. The report also preceded a notorious tort law decision, the Wagon Mound, which imposed on English law a rule that damage which is too remote as a consequence from a faulty act will not be compensated. This threw out the established directness test. the recommendations, and the subsequent act, plainly reflect the prior legal position, and are accordingly more claimant-friendly on three grounds. First, there is no need to prove the problematic Hedley-Byrne special relationship. Second, there is no remoteness cap on the damages which may be claimed under S2(1). And third, possibly reflective of a growing academic favor for claimant rights and strict liability, the burden of proof is on the defendant to show he has not been negligent. The text of Section 2(1) reads as follows. An illustration of the burden of proof is given in Howard Marine and Dredging Company Limited v. Ogden and Sons Limited, where a shipping company told a client that its barge for hire would hold 1,600 tons. This is what the Lloyd's Register of Ships said. But the ship's own documents, accessible to the shipping company, said the barge could only take 1,055. The Court of Appeal held that in preferring a more convenient source over another, the shipping company had not been reasonable. It was up to the shipping company to positively prove this, and in the circumstances looking to the register was not reasonable. It is likely that a company's own standards and practices will be relevant to what constitutes reasonable grounds for a belief. The point about remoteness of damages under S2(1) was treated in the controversial case of Roy Scott Trust Limited v. Rogerson. Here Mr. Rogerson bought a car on hire purchase, from a Honda dealer, financed by Roy Scott Trust Limited. When Mr. Rogerson fell behind in his repayments and sold away the car, Roy Scott Trust Limited sued the Honda dealer, because they found it had misrepresented the proportion of the deposit Mr. Rogerson had put down for the car. On this basis they argued that Honda was liable for them not being able to recover the cost of the loan. Roy Scott Limited argued that the loss was too, or that Mr. Rogerson's wrongful sale was a break in the causal chain. But the Court of Appeal held that in any event the test under S2(1) was the same as in the tort of deceit, that one should be liable for all consequences. Balcom L.J. said this followed from the clear wording of the Act. It will not always be possible to sue under S2(1), however. If there is no contract, for instance if an agreement was void ab initio on the ground of non est factum, then it will be necessary to sue under Hedley-Byrne. Also, the misrepresentation must precede the contract, and is not actionable under S2(1), even if it is found in the contract subsequently. Lastly, it has been suggested by McKendrick that if S2(1)'s application leads to draconian consequences, a court may not be willing to enforce it. Innocence, Misrepresentation Act 1967 S2(2) equals. At common law, as for all forms of misrepresentation, innocent misrepresentation gave rise to the right to rescind a contract. It was not possible to get damages, but so long as one was not confronted by a bar to rescission, the misrepresentee had a right to escape the contract. When the Misrepresentation Act 1967 was passed, it was decided that this right to rescission could be used in a way that was unfair on a misrepresenter. So Section 2(2) gives the court a discretion about whether it will allow rescission of a contract, or substitute an appropriate award of damages in lieu. In William Sindel plc v Cambridgeshire CC, William Sindel plc claimed rescission of a land purchase from Cambridgeshire County Council on the ground that the council falsely stated there were no sewage pipes on the property. This would have cost £18,000 to remove, and the land had been bought for £5 million. The real reason that William Sindel wanted to escape from the contract was that land prices had just crashed. The court held that in fact the contract had made the buyer assume any risk of such representations and there was no right to rescind. But if there had been, it would have exercised its discretion under S2(2) to award a small sum of damages. Although it has been suggested otherwise, the right of the court to award damages in lieu of rescission only exists if the right to rescission exists. So in Government of Zanzibar v British Aerospace Limited, because it was impossible for the government to give back its executive jet, it could not ask the court for damages under S2(2), instead of rescinding its contract. Exclusion clauses. Attempts by contracting parties to exclude liability for misrepresentations are subject to the same restrictions as are found for exclusion clauses generally under the Unfair Contract Terms Act 1977. It was held in HIH Insurance Limited v. Chase Manhattan Bank that it is never possible to exclude liability for fraudulent misrepresentations. But it is possible to exclude liability for negligent misrepresentation, liability under Misrepresentation Act 1967 S2, 1, or innocent misrepresentation. The requirement, however, is that the exclusion is reasonable according to UCTA 1977 S11, in conjunction with SCH2. Same issues as are found in the UCTA 1977 cases arise under S3. First, by analogy to UCTA 1977 S13, a clause could be held to be not an exemption, but a duty-defining clause. This was the position in Overbrook Estates Limited v. Glencombe Properties Limited, where a condition at an auction stated the auctioneer was never given the authority to represent that the properties were not going to be compulsorily acquired by the council. By contrast, in Cremdn Properties Limited v. Nash, it was held agents of a seller of some Bristol business property always had authority to make general representations, so a clause purporting preclude any guarantee for accuracy of representations was an exclusion and subject to S3. The reasonableness test itself can be seen in operation in Howard Marine and Dredging Company v. A. Ogden & Sons Limited and Walker v. Boyle. In Walker, two private parties, albeit both with solicitors acting on their behalf, had made an agreement to sell a country house. Some standard terms called the National Conditions of Sale were incorporated, and these contained a clause excluding liability for misrepresentations. Even though these terms were widely used, it was held that between the parties their use fell foul of the Misrepresentation Act 1967 S3, since they were not negotiated by interested trade parties. A court will weigh up a number of considerations, but the most important consideration is what the bargaining strength of the parties were. Cleaver v. Skyd Investments Limited, 2011, EWCA Civ 929, Laws L.J., Longmore L.J., Etherton L.J., held that the standard conditions of sale para 7.1.3 was not fair and reasonable, as the judge had concluded, and not effective under the Misrepresentation Act 1967 S3 and Unfair Contract Terms Act 1977 S11. So a purchaser of land was entitled to rescind the contract of sale. Consumer protection. An important contemporary dimension to misrepresentations is the statutory regulation of business, and enforcement measures by the Office of Fair Trading against unfair trade practices. Typically, consumers do not understand legal complexities and have little incentive to litigate over small claims. Statute may also strengthen enforcement of consumer protection by providing criminal or regulatory sanctions. The Trade Descriptions Act 1968 SS 1-4 say that not only false, but also misleading statements about products are prohibited. An early example is found in Robertson v. DeSico, where it was held that describing a vehicle as a Euro beautiful car a Euro unregistered trademark was implicitly saying it was fit for purpose. Though the exterior was attractive, it was still a misrepresentation when the car did not work. Similarly, the Consumer Protection Act 1987 SS 20-21 create an offence for giving misleading information about the prices of goods and services, such as banking or insurance. On top of this, the Unfair Commercial Practices Directive, give a broad principle-based jurisdiction to courts and the OFF to clamp down on misleading practices or omissions by businesses. Mistakes about identity. One area which English law takes outside the ordinary law of misrepresentation is what is typically called mistakes about identity. In this group of cases, the common fact pattern is that Alice gives a valuable good to Bob thinking that Bob will pay. Bob is a fraudster and has misrepresented his identity or creditworthiness or both, and has left Alice with a dud check, or simply does not fulfill a promise to pay later. The valuable good is then sold by Bob to Claire. Bob disappears and cannot be charged for fraud. Alice finds that Claire has the valuable good and sues Claire to get back the good. The dilemma courts face is whether to prefer one innocent party over another innocent party. Alice has been a victim of fraudulent misrepresentation. Claire is also defrauded in the sense that Bob represented to her that he had good title to the good he sold on. Claire has paid good money for the good. But because Bob cannot be found, Alice has no remedy. Were the issue treated as one of fraudulent misrepresentation, the simple equitable principle to be applied would be that the contract is voidable unless third-party rights have intervened. The defrauded party has a right to rescind the contract, until the point where Claire's rights had intervened. Claire could be considered a bona fide purchaser for value without notice of any pre-existing interest, and should take full title to the property. This was essentially the approach advocated in Lewis v. Avery. However, it is not the stance English law is currently taking. In Shogun Finance Limited v. Hudson, the House of Lords by 3-2 decided to uphold an older line of authority which declares a contract void from the start. If there was never any contract between the seller and the fraudster cannot sell any property right to the third party, because they never had a good property right in the first place. This follows the Latin maxim, nemo dat quod non habet, that one cannot give what one does not have. So the present law is that if a person deals with another by distance, that person's presumed identity is recorded in a document, and it turns out that that person is in fact an uncreditworthy rogue, then the third party cannot acquire good title and the good must be returned to the original person who is defrauded. The minority of the House of Lords preferred to follow Lewis v. Avery, which is in line with the law across Europe, in the United States and most of the rest of the world. See also, good faith, English contract law, U.S. contract law, German contract law, French contract law, Principles of European Contract Law Arts 4107, 4116 and 4117, Misleading or Deceptive Conduct, Tort of Deceit. Notes. References, books and chapters, P.S. Attior, Introduction to the Law of Contract H. Beale, Bishop and Firmston, Cases and Materials on Contract Law, A. Burrows, Cases and Materials on Contract Law ch. 11 hours Collins, Contract Law in Context, E. McKendrick, Contract Law ch. 13, E. Peel, Triacle, The Law of Contract ch. 9, Articles, P.S. Attior on G. Triacle, Misrepresentation Act 1967 feet 30 ml 369 picoseconds Attior, Res ipsa loquitur in England and Australia 35 Modern Law Review 337, R. Taylor, Expectation, Reliance and Misrepresentation. 45 ml 139, R. Hooley, Damages and the Misrepresentation Act 1967 feet 107 LQR 547, arguing that fraud and negligence are qualitatively different and should be treated differently in order to reflect fraud's greater moral culpability. He says the Misrepresentation Act 1967 S2, 1, establishes only liability and damages but not their quantum, so Roysott was a poor decision. I. Brown and A. Chandler, Deceit, Damages and the Misrepresentation Act 1967, S2, 1, 1992, LMCLQ 40, H. Beale, a damages in lieu of rescission for misrepresentation unregistered trademark 111 LQR 60, J. O'Sullivan, Rescission as a Self-Help Remedy, A Critical Analysis, 2000, CLJ 509, W. Swadling, a rescission, Property and the Common Law unregistered trademark 121 LQR 123, suggests the reasoning on recovery of property should not merge the issues of validity of contract and transfer of title. He controversially says the two are separate. So Caldwell should not have got his car back. Rights in property are passed on delivery and with intent to pass title. This is not dependent on the validity of the contract. In short, he argues for the abstraction principle. Bihar currency CKER, a rescission of contract and revesting of title, a reply to Mr. Swadling unregistered trademark, 2006, RLR 106, responds to Swadling's argument. She point out flaws in Swadling's historical analysis and conceptual analysis. J. Cartwright, Excluding Liability for Misrepresentation in A. Burrows and E. Peel, Contract Terms 213.